Okay, welcome everyone. Thank you for joining us. Today we're going to talk about estate planning in the time of coronavirus. And if there ever was a time for people to get their affairs in order, this is definitely it. A little background on myself. My name is Mark Bowdis. I've been in the financial industry over 20 years and own a financial planning company in Montclair, New Jersey. So one of the things we've learned during the pandemic is that things can change on a dime, especially when it comes to our health. We saw a lot of people engage us for financial planning help. And one of the areas that people had a lot of anxiety around was estate planning. So, in addition, there's still a large percentage of people who don't have an estate plan in place. But today we're not going to talk about estate planning in its entirety. Instead, we're going to talk and focus on what can be done right now to offer some immediate protections. We see one of the hesitancies to putting an estate plan together is that, you want to put that perfect plan together. And we're firm believers in having a robust plan. But for right now, there are several things you can and should do. And we know there's a lot going on in everyone's life right now. But, we hope to really, get across the urgency of getting certain documents done, whether you're doing them for the first time or updating them in light of what's going on, still going on through the pandemic. If you have any questions, please put them into the Q&A section. I have my colleague, Kira Mackesy, on here as well. She'll be monitoring the Q&A, and I'll take stops during the presentation to see if there are any questions. So we're hit with these numbers constantly. And as of May 5th, 2021, which is yesterday, there's been over 33 million infections and almost 600,000 deaths in the US from COVID. But the good news is we've seen a sharp decline in cases, hospitalizations, and deaths recently. Things are getting better, and we're hearing more and more announcements every day of things getting back to normal. So while the title of this presentation is Estate Planning During the Time of Coronavirus, what we're going to talk about holds true during any time. So this is a graphic from the Washington Post, and it was from a week in April last year. And at that time, COVID-19 was the second leading cause of death in America. And hopefully it goes away and never comes back. But the one thing to take away from this is there are other things that people are dying from, and it's best to be prepared. So here's what can go wrong if you're not prepared. Number one, there can be inappropriate medical decisions if there's no advance directive. And there are unique considerations with regard to COVID in that area. Some of you may have signed a living will saying you didn't want to ever be put on a ventilator under any circumstances. But we've seen that ventilation is a relatively common treatment for COVID, and many people have recovered completely after spending some time on a ventilator, even people in their 90s. This is one reason to review any healthcare advance directives in light of this, illness going on. On the other hand, there may be reasons why you might not want to be put on a ventilator, such as not wanting to be left in a weakened state. The point is that medical personnel will do whatever it takes to keep a patient alive unless they're authorized to withhold certain treatments via advance directive. Number two, no one is making financial decisions if there's no power of attorney. Let's say a small business owner gets sick, gets admitted to the ICU, and has no one authorized to carry on the business, meet payroll, conduct transactions, and so on. This could go on for weeks. Even individuals with relatively simple finances need someone to pay the bills, transfer money, and so on. So a power of attorney for financials is essential. Then what if you don't make it? Assets will be in limbo if no estate planning measures are taken. Loved ones wouldn't know what to do or where to turn. In a little bit, we'll talk about what everyone's default estate plan is. So today we're going to talk about some things you can do right now to put some of these estate planning measures into place. Again, it's not full-blown estate planning. We're certainly getting calls for that too now, and especially in light of some of the recent tax proposals that come out, where there are proposed changes to things like the estate tax exemption, canceling the step up in basis. We're preparing a webinar that'll cover strategies to minimize taxes as part of estate planning. But for those of you who have done the full-blown estate planning, all that may be necessary here is to review your documents, maybe make a call to your estate planning attorney, seeing if anything needs to be done. Here in this presentation, we're going to talk about some of the things you can do yourself, even without an attorney. Again, we're proponents of using an attorney, and if you already have an attorney that you work with, by all means, seek out their assistance. And by the way, nothing in this presentation constitutes legal advice. We're educating you on common estate planning documents and obviously encourage you to seek professional legal advice for your own specific situation. So here are the essential estate planning measures you can take right now. And I'll be talking a little bit more on each of these. First, an advance directive for healthcare. Second, a power of attorney for financial decisions. Third, make sure your assets are titled properly and beneficiary decisions are up to date. Fourth, a simple will to appoint an executor and, if applicable, a guardian for minor children. And fifth, letters to loved ones. So as you're thinking about these things in relation to your own estate planning, don't forget to consider your other family members. Maybe you have parents who never did their estate plan or adult children. An 18-year-old child would be considered a child by most of us, but they're an adult in the eyes of law and HIPAA. So in order to get, for their parents to get information about their medical condition, there should be a HIPAA release signed by the child who's no longer a minor. And this really comes into play with children going off to college. Okay, first we're going to talk about planning for illness or incapacity. So these are advance directives, and today they generally combine a living will and a power of attorney. The living will allows you to state your healthcare wishes in the event you're unable to communicate or make decisions. The power of attorney allows you to appoint someone to interact with medical personnel on your behalf. And here are some of the advanced care goals that are usually listed on these documents. Then what you have to do is you decide which are most important to you and prioritize them, such as being free from pain, being with family, being able to feed, bathe, and take care of yourself, not being a financial burden to your family. Then the document may also allow you to state preferences in case of terminal illness or irreversible brain injury. And it lets you state your end-of-life preferences, such as where to die, at home or in the hospital, and organ donation. Before COVID-19, going on a ventilator was usually considered a last resort. People who didn't want to be kept alive by artificial means would generally state that they did not want to go on a ventilator. But COVID has changed a lot of this. Ventilators have saved thousands of lives, and while a lot of people do die after going off the ventilator, many others, especially young people, do recover. There have been articles on the lasting damage a ventilator can do to a person, such as extreme muscle weakness, inability to perform basic tasks like driving or grocery shopping, cognitive impairment, and the higher chance of dying over the next year. Obviously, you'll have to use your judgment here. If someone is older and weaker to begin with, they may not want to go on a ventilator. And anyone who wouldn't want to end up in a compromised state may opt out of the ventilator. Others who would want to stay alive at any cost would want the ventilator and any other procedure that might keep them alive. The main thing is that people who already have living wills and who have stated that they never want to go on a ventilator may want to revisit that decision in light of COVID and perhaps word it differently. So, these are all tough decisions, and there's evidence that people anticipating end of life don't really know how they'll feel until they get there. It's easy to say you don't want to be kept alive by artificial means, but will you still feel that way when you're close to death? One reason put off doing their advanced directive for healthcare is that they don't want to make those decisions. And while not life and death, an analogy is when I talk about risk with someone in their portfolio, I'll talk about it and they say, yeah, I want to be aggressive and I want to get the highest returns possible. And I'm okay if, there's a market drop and my account value goes down. But then when they actually see the drop and when it actually happens and they get that gut punch looking at their statement or looking at their balance, they think, well, maybe I didn't really want to be so aggressive. So we obviously never know, until we experience something, but, you just have to make the best decision you can right now. And, if things change, if circumstances change, you can always change that decision or change that document. So that's why it's also a good idea to name a healthcare agent who can interact with doctors and make decisions on your behalf in real time. Without the living will, it's too much of a burden to place on loved ones. But without the healthcare power of attorney, you don't have someone covering the gray areas where, like, the decision to go on a ventilator or have a feeding tube is not so clear cut. The healthcare agent can talk to doctors and listen to the prognosis and weigh the pros and cons at the time the health event is happening. When choosing a health agent, it obviously should be someone you know and trust and someone who's competent and able to understand both your wishes and the treatment options. It's usually recommended that it be one person in order to avoid confusion and disagreement at the time quick decisions need to be made. So you might name a primary and a contingent agent. Usually the healthcare agent, they're able to be in the hospital meeting with the doctors in person. But we saw during the pandemic that usually that might not be possible. So some attorneys are recommending that the healthcare power of attorney have a provision for electronic communications by phone or email, and that it releases the medical team from liability if they take instructions that way. Advance directives are governed by state law. Most states require 2 witnesses or a notary, and some states do require both. So here are some of the sources for advance directives. 5 Wishes is offered through an organization called Aging with Dignity. They offer the form for, I think it's $5, as well as a conversation tips for individuals and families. And the 5 Wishes form has been approved by most states. Or you can download your state's form from the National Hospice and Palliative Care Organization. Also, most healthcare providers have their own form, which you can call and ask your own doctor to mail it to you. Because it's so easy to let barriers stand in the way of doing the advance directive, here's one idea. Go to mydirectives.com, and this form is all digital. You check the boxes to indicate your healthcare preferences and appoint your healthcare proxy online. You can choose a primary and a contingent person to interact with doctors on your behalf, should you become unable to speak or give directions. The form is emailed to those people who are prompted to accept the assignment. Then to validate, you enter the names of 2 witnesses. An email is sent to them for digital signature, and then the signed form is stored online. It can be forwarded to anyone you name, such as a healthcare provider. You can also download and print a PDF and wallet card with a link to where the form is stored online. And I suppose an attorney might question the legality of the form because the 2 witnesses do not literally witness your signature. It's all done digitally. But there's the thing about advance directives. Some version of the form is better than none. And maybe it's easier to get witnesses now than it was a year ago. But doctors and patients and family members, they're making life and death decisions all the time, usually without an advance directive in place. So advance directives, they're designed to reduce liability for the medical team. It essentially gives them permission to pull the plug. But in real life, doctors are discussing treatment options with family members and making the best decisions they can, without worrying about litigation. So an advance directive does not force a doctor to do or not do a certain thing. It merely provides guidance on what the patient would want. And if we get too hung up on the legalities of the signatures, we could be depriving the medical team of this important guidance. So one last thing I want to say about advance directives is to reiterate this warning. If the advance directive says no ventilator, it could cause life-saving treatment to be withheld if you have COVID or some other illness that would warrant a ventilator. Most people, when they sign these things, assume they'll be on their deathbed when the ventilator decision comes up. So check the language. If it says no ventilator, if no hope of recovery or some such language, it's probably okay. But if it says no ventilator under any circumstances, you may want to change it. And a final tip about healthcare, make a grab-and-go envelope in case you have to be rushed to the hospital. This is good to have not only during the pandemic, but anytime. When there's a healthcare emergency, people don't always have their wits about them. And it'll be much easier on everyone if you have an envelope that's easy to grab that has these things in it. You want to have a copy of your healthcare directive, a list of medical conditions, a list of medications and allergies, the names and phone numbers of the primary care doctor and the healthcare proxy, and any insurance cards that you have. And once you made this envelope up, keep it in an obvious place, like next to your keys, kitchen drawer, that's easily accessible. And then also make sure your spouse and children know where to find it as well. Okay, now let's talk about power of attorney for finances. This document gives another person the power to pay bills, transfer money, manage investments, buy or sell real estate, manage digital assets, and more. The power of attorney can issue broad powers or specific powers. The 2 characteristics you want in an agent are honesty and competence. You might choose a spouse or an adult child, or even a professional, such as an accountant. What you want is a durable power of attorney. This means that it takes place immediately upon signing, and it remains in force until either you revoke it or you die. It specifically stays in force if you become incapacitated, which is the whole reason for doing it. The other kind is a springing power of attorney, which is not as good. A springing power of attorney doesn't go into effect until the happening of some specific event, usually a certification of incapacity. So people sometimes do these because they don't want their agent taking over their finances before they become incapacitated. But for it to go into effect, you need a certification of incapacity, which may take time, which is obviously critical, depending upon what's going on. And if you're naming someone you trust, you shouldn't have to worry about that person taking over your finances while you're still able to take care of things yourself. So, for a quick and dirty power of attorney that you can do yourself, you can download a standard form from US Legal, Law Depot, or the LegalZoom websites. Again, I recommend doing estate planning through an attorney, but for some people who want to get something done quickly, there are some other options that people have. So Kira, I'll stop there. Any questions that we have right now?
So far, there's no questions right now. If anybody does have a question, please feel free to drop it into the Q&A box at the bottom of the screen.
Perfect, thanks. Okay, so just a couple more things on the power of attorney. There could be issues with the power of attorney when it comes to dealing with specific financial institutions. So it's like one thing to draw up and sign your power of attorney, and then it's another thing sometimes for the agent to actually be able to act when the time comes. Most banks and other institutions have their own form, so be sure your agent's authorized to act. And what's probably best is go to each institution that you have financial relationship with and get their power of attorney form, just to be safe and know that what you have in place will actually be allowable. The Social Security Administration doesn't recognize a power of attorney, but they have what's called an advanced designation program that allows you to name a person to serve as a representative payee in case you become incapacitated. So to do that, you just have to go to the ssa.gov/myaccount website. And if you don't have an account, open one up and you can click on the advanced designation button and get started with that. If you have put all your assets into a living trust, you may give the successor trustee the power to step in at any time and take over the management of trust assets. This serves the same purpose of the power of attorney, but it only deals with the assets that are in that trust. If there are any assets outside the trust, the successor trustee wouldn't be able to deal with them. The same caveat goes for financial institutions. There could always be some question whether the institution would actually take instructions from the successor trustee. So again, it may be better to use the institution's own power of attorney form. And there's also signing issues for the power of attorney. Some states require 2 witnesses, no notary. Some require 2 witnesses or a notary, and a few require 2 witnesses and the notary. One place you can go to LegalZoom to check what the latest state laws are. And by the way, if your power of attorney is valid in the state where it's signed, it will be valid in other states as well, such as when you're visiting someone in another state. However, if you do move, of course, it's obviously best to have new documents drawn up. Some states allow for remote online notarization, but both the client and the notary sign in real time. All right, we got a little hiccup there. But here's a list of states that allow for remote online notarization. Other states, they're in the process of fast tracking some of these laws. All right, so that takes care of the quick and dirty incapacity planning. And once the pandemic has passed and life resumes to the new normal, you can revisit these plans and make whatever changes are necessary, but at least you'll have something for now and you'll get something in place. And the unique thing about coronavirus is, and it's just a thing in, with health in general, is things can change so quick. And emotions are running all different ways now with us, and everyone's nervous and thinking about getting their financial affairs in order. But you have to look at this from the proper perspective. You're not doing this for yourself. You'll be dead. You're doing it for the people you love. If you were to suddenly die, what would your loved ones do? So think about it from your spouse, your partner, your adult children. Would they know what you have and where everything is? So when this presentation's over, sit down at the desk or kitchen table, pull out all of your account statements, your bank accounts, investment accounts, IRAs, retirement plans at work, insurance policies, really everything, anything that you can think of that's an asset that you have, and your financial institution's account numbers, contact information, and that way the people who you have to notify in case something happens. Some financial institutions are different. Some have specific instructions, but put yourself in your partner or your son or daughter's shoes and ask yourself, what do they need to know to pick up the pieces, if something does happen. So, approach death planning from that perspective of the people who will go on living. How can you make your death easiest for them? And, that's really what getting your financial affairs in order is all about. Keep it in mind that we're talking about quick and dirty estate planning that you can do immediately. Where something's better than nothing until you do a full-blown estate plan. We'll start with account titling and beneficiary designations. And the reason we do this is because at death, these assets pass directly to the co-owners or the beneficiaries outside of probate by the operation of law. If you also have a will, the methods of ownership transfer supersede the will. In the case of a bank and investment accounts, if these are owned as joint tenants and one owner dies, the co-owner assumes full ownership. Or if the accounts are titled as payable on death or transfer on death, the assets go to the named individual. So let's say you change the title of your bank account to payable on death or POD, listing the name of your daughter. When you die, all your daughter has to do is contact the bank and present evidence of your death, and the account will be retitled in her name. In IRAs, retirement plans, and life insurance, all pass by beneficiary designation, which is similar. This is also one of the most direct ways to transfer assets. All your beneficiary needs to do is contact the institution and present a death certificate, and the account will be retitled in their name. Same with life insurance. Proceeds are immediately paid out to them without going through the court of law and going through probate. But we can't emphasize enough the importance of informing your loved ones about these assets. You don't really want to have them dig through papers looking for possible accounts and insurance policies that may or may not exist. 27 states allow transfer on death deeds for real estate. If your state allows for the transfer on death deeds for real estate, you can set it up so that your beneficiary is able to immediately retitle your house or other real estate without going through court. And you can get those forms through your county auditor's or documents office. And you may have to pay a fee. It also may have to get notarized. And once you have all your accounts set up to pass to your loved ones by beneficiary designation or payable or transfer on death, it'll be easy to have title transfer them without going through a court. And it makes it easier at the time that they're grieving your death. And it should be mentioned that if you have a complicated family situation, maybe second marriage, blended family, multiple beneficiaries that you want to leave different amounts to, these simple methods probably won't work. In some cases they may, but in that case, again, I'm going to reiterate, you should see an attorney who will be able to customize, your wishes and make sure that they go to the right people without, with a minimum hassle and fees involved with it. If you're able to have most of your assets pass through joint ownership or beneficiary designation, your estate may qualify for a small estate probate exemption. And if the estates passing out of these methods are under a certain amount, your loved ones won't have to go to court to go through probate and settle your estate. So here's an example of a case where a single person owning nearly $1 million worth of assets, but only 35,000 of it is personal property, and that's the only amount that would be subject to probate, because the rest of it is transferred by beneficiary designation or operation of law. So if the 35,000 is under the state's small estate exemption, there'd be no probate and no court involved at all. So it's something to look at. If everything is passing outside of probate, you won't even need a will because you won't go through court. But it's a good one to have everyone to have in place, because what it does is it puts someone in charge of distributing your remaining assets that don't transfer by beneficiaries or payable or transfer on death, deciding who gets the car and so on. And if they're minor children, you definitely need a will to name a guardian. I really reiterate this as, the one of the most important reasons for putting a will in place. Again, recommend, going through an attorney, but you can do this there is a quick and dirty way to do it, whether it's, Willmaker, LegalZoom, Law Depot software. We even have some software that we've worked with that can do similar. These do-it-yourself wills, they're valid if they're signed and witnessed by 2 witnesses. But again, a state attorney, you may have a complicated estate, or you may just feel more comfortable going through an attorney. And obviously we recommend that as well. There's always a default estate plan. If you don't have a will, if you don't have guardians for your children name, the state will decide. What we're looking at here is the intestate rules in New Jersey. And this is just the flow of what happens to your estate if you die without a will. And this may be exactly how you wanted your estate disposed of if something happens to you, or maybe not. But this is the procedure that's going to happen to you. It's similar for guardianship for your children. People can petition the courts to become a guardian. There may be some interfamily disputes or fights on who's the guardian if you don't name one. But either way, your guardian may not be who the states decide, who the courts decide, may not be your first choice. One of the holdups I see with people putting a will together is naming a guardian for their minor children. You have the one spouse wants one person, another spouse wants another. My recommendation in that case is just name the best person for right now. You can always change it at any point in the future if things change, if you decide someone else is a better guardian for your kids. Once the advance directive and power of attorney have been signed, the accounts titled it properly, beneficiary designations are updated, wills drawn. Last thing is a letter to loved ones. And again, important thing is to look at your death from the survivor's point of view. What can you tell them to make life easier for them? So first, there are some practical matters: how to get into the house, get the mail, care for pets, basically telling loved ones how to pick up where you left off. And you'll want to write down a list of all your bank and investment accounts, name of each institution, account numbers, contact info. You want to list the people to be notified at the time of death, like employer, advisors, family, friends. Include a list and location of ownership papers like deeds, insurance policies, vehicle titles, a listing of location of valuables, website logins and passwords. This whole world of website logins and passwords gets into a lot of legal gray areas. For example, if your daughter has access to your computer master password and the computer's keychain has all your passwords stored, what's to keep her from logging onto your bank account and moving money around? Or what's to keep her from, posting on Facebook? And you obviously probably trust your kids and feel that giving them access to your computer will make their lives easier. But there's also some legalities that come across as well. And like, for example, most online entities like Facebook, email providers, they have policies and procedures that they have in the case of death. But it could be a nightmare forcing loved ones to check each company's policies before they can deal with an online account. So, this is obviously too big a discussion for this, but the point is you may want to leave behind a letter or some sort telling your loved ones what you have and where everything is. And then there's obviously all the sentiments that need to be expressed. So here I have a link to the Stanford letter project, and this is great for this. You do a life review, and in your letter, you acknowledge the important people in your life. You remember treasured moments. You may want to apologize to those you love if you've hurt them. You forgive those who you love if you've hurt, if they hurt you. You express your gratitude for all the love and care you've received. You can tell your story to friends and family, how much you love them. And, you take a moment to say goodbye. And it doesn't have to be complicated or long and involved. And again, it's something is better than nothing. And, you can just start jotting some of these things down. And, like I mentioned before, you never know when it will be too late to do something. So here's a summary of steps for the quick and dirty estate planning. Right now, complete and sign a healthcare directive that combines a living will stating your wishes on how you want to be treated and the name of the person you want to serve as your healthcare proxy. Number 2, complete and sign a power of attorney for finances. Number 3, check your account titles and beneficiary designations. And number 4, draft your will, simple will. And number 5, write a letter to loved ones. So, these seem simple steps, but they'll go a long way to easing your estate planning fears and anxiety around it. Obviously, hopefully nothing happens to anyone, but you'll feel much better having these things done. Then once the ball's rolling, you can go on to do more comprehensive estate planning. You can organize your records, call an attorney, work on your legacy. This is a screenshot of our legacy planning checklist that we use to help clients get organized. It's a checklist of things that need to be done to complete your estate plan. The things we've talked about today will get you by if you become incapacitated or unable to express your medical wishes or take care of your accounts. But there's more to estate planning than just those things. So once you've done the serious aspects of estate planning, you can get to some of the fun things. And these are what we call legacy planning, which is passing down all those intangible things like memories, family stories, values, beliefs, and so on. How do you want your children and grandchildren to remember you? So these worksheets they'll jog your memory. By asking you to write down things like significant life events, your family ancestry, what life was like when you were growing up, where you lived and traveled, relationships and family, your favorite things, and views and values. Each worksheet has questions that will help you remember some of these things that your children and grandchildren will treasure. And these memories can be lost forever if you don't capture them in so using some kind of tool like this. So I'm glad you're here today. So many people put off doing their estate plan, and their family really does suffer when it isn't done. If the coronavirus has motivated you to start getting your affairs in order, then it's definitely something to take action on. Today we talked about the most essential things that need to be done, and I hope this puts you on the path to a more complete legacy planning. And really, your legacy plan's all set when, one, you have a trusted person who's ready to step in and help if it becomes necessary. 2, your records are organized and accessible. 3, your loved one will be provided for after your death. And 4, you'll be remembered for your unique contributions to the world. It's not hard. It's just, one of those things that you have to get started on. So thank you for your time. I hope you learned some valuable information today. If you'd like to learn more, or if you want those legacy planning materials I've mentioned, you can give me a call, shoot me an email. Here's my contact information. We hold webinars every 2 weeks. Our next one is titled "What's New with Social Security? 7 Topics to Watch in 2021." You can register for that upcoming webinar, any of our other upcoming webinars, or watch replays of past ones on our website, bautisfinancial.com/learning center. So again, thank you, and we'll see you soon.
Mark, we do have a few questions if you have a few moments.
Sure, of course.
So we have a few questions about trusts. First, can you discuss the difference between a will and a trust? And second, do you advise trusts?
Sure. So difference between a will and a trust. So a will, it's a legal document that spells out how you want your affairs handled and assets distributed after you die. The trust, it's a fiduciary relationship. Basically, you're putting assets into a trust, and you're giving the responsibility to a trustee they got the right to hold title, manage those assets for the benefit of a third party. So for example, let's say your will, you want your grandchild to have, some of your assets, or you want to leave them money. If you put that in the will, they'll get access to those assets. However, if you want something a little more complicated, or you want to provide a little more direction on how they should inherit those assets, a trust is an example of how you could do that. You could say, well, I want to leave the money, but I want to make sure it's used for education, or it's used for buying their first home, or starting a business, or something specific. Trust, we could have a whole webinar just on trust. they can get complicated. Some of that, what I talked about earlier is how we're putting together a webinar on some tax mitigation strategies during estate planning. So there are certain flavors of trusts that cover that. So we'll go into, in that webinar, we'll go into some detail on how people can use trust for that. And, the second part of the question is, do you recommend using a trust? And it's, everyone obviously is different. So for some people, it definitely makes sense. Some people maybe not make sense. And, it's a legal document that one of these documents, you're most likely not going to go to LegalZoom and you're going to work with an estate attorney to do it. And then what you'll see is every estate attorney is different. Some, will recommend this type of trust or this type of, trust. Some can be on the extreme side of they go crazy with just, all right, let's build this trust, this, and all of a sudden you have 10 different trusts that's created when maybe one or two is probably what's necessary. So to answer it broadly, it obviously depends, but there are a lot of cases where trust can come in and are useful.
Great. And there was another question asking if you recommend using LegalZoom for creating a trust, which you just touched on. You don't necessarily recommend LegalZoom for trust because it can get complicated. We have another question asking how someone should prepare for a meeting with an estate attorney.
Yeah, so I think this is one of the things I see as a holdup why people don't move forward with working with an estate attorney. It's that, oh, I don't, I have to get everything ready. I don't even know what to get ready. I have to talk to my spouse about what we want to do. And, you want to make things simple. You want to always keep moving or keep making progress. Especially, estate planning is one example of that. And if you do work with an attorney, they're probably going to have some kind of intake questionnaire. Like what I mentioned earlier, you want to just list your assets and list how they're titled, because that, that they look at that, they do analysis on that, and that's how they can make advice or give recommendations. That's part of what they want to know. Try and gather as much financial documents as you can. If you do have some estate plans in place, maybe you did a will, and that's what I see a lot too is, I did a will 10 years ago, it's outdated. And, get whatever you have in place and bring that. And then there's other legal documents that they're going to want to know about as well, whether it's a divorce agreement, premarital agreements, any other kind of agreement or contract that you have in place. And, you want to start thinking about who your executor is, if who your healthcare agent would be, or if you want to have a power of attorney, some of those things that we talked about earlier. And again, you don't need to get overwhelmed. And because what happens is a lot of people get overwhelmed and they just say, you know what, we'll work on this next week or next month. And then all of a sudden months and, years go by. So it's just kind of gather as much as you can that is, makes sense, and just move forward. If they need more information, they'll ask you for it, but, just keep making progress with it.
Great. And then our final question is, can you explain the difference between tenancy in common and tenancy in entirety?
Sure. So, yeah, one of the differences with tenancies, and this is another thing that I had talked about before, is getting your whatever assets you have, looking at the titling of them, because what happens a lot of time is someone, they create an account at a bank, and the person that they create the account with, they just have, it's a joint account. They just have a default way of doing it. Maybe it's the last account that they created. But there is a difference, between joint accounts and, the two, we see joint tenants in common, which basically mean, and this is obviously if something happens to either person, what in common, and the other common one we see is with rights of survivorship or entirety. So, for example, two people have it, rights of survivorship, one person passes away, entire account automatically goes over to that other person. Tenants in common is a little bit different. So let's say, two people are joint ownership to something, one person passes away, the other part, it would go to their estate, which may or may not be that same person who is, who they have that tenant in common with. So again, just reiterate, it's, check with how these accounts are titled, because they could, and it not just what happens to the asset, but there are tax implications to how the assets are titled as well.
Great. That's all from the question and answer.
Okay, great. So again, thank you everyone for joining. Again, anyone has any questions, we do offer a free consultation. So, you can reach us through our website. My email, phone is also included there, and hope to see everyone on a future webinar.